The Supreme Court of Ohio conducted oral arguments in April, including a session of off-site court at Monroe Central High School in Monroe County. Before an audience of students, the justices heard 3 cases dealing with a variety of legal issues. First, a Montgomery County man is appealing his conviction for menacing by stalking. Dorian Crowell commented on Instagram about a woman he went to grade school with more than 20 years ago. They were never friends, and the two had never spoken to each other. He told her in the post that he loved her and hoped to see her soon. Weeks later, he showed up unannounced at her door. She was frightened and called the police. He argues his friendly social media posts aren't part of a pattern of conduct that constitutes stalking. The justices had questions about his actions.
The real thing that seemed to cause fear was him walking up to her house uninvited, trying to turn the doorknob. That is, that's the culmination here that creates the pattern.
What we're talking about is bootstrapping now that bad conduct, bootstrapping it to something that was benign, something that was different, something that was posted there. And if we do that every time I put someone in fear, oh my goodness, and I've happened to post things on their social media, does that make me a stalker?
The prosecutor argues the pattern can start with non-threatening behavior and escalate to acts that are criminal.
The way I saw it was a buildup, kind of an increase in intensity over time. Is that's where you're getting to pattern?
I agree, Your Honor. I agree completely with that statement, because what happens here is he says inappropriate, intimate comments. Then it's directed towards, is this where you live, and see you soon? And guess what? He does that.
The Ohio Attorney General's office urged to uphold Crowell's conviction and said his acts could be seen as causing the victim to feel mental distress.
When did he first have knowledge, the perpetrator,
Right.
that he was causing her fear or mental distress?
A reasonable fact finder absolutely could conclude that before he touched the door handle, he knew this is going to cause fear. He almost basically said that, because he said that he told the officers he was there to confront her about not responding to his post.
A Lorain County man challenged his conviction for aggravated vehicular assault for hitting and injuring a state trooper who was directing traffic. Edward Balmert had taken hemp products early in the day to address medical conditions, including arthritis and vertigo. At the time of the accident, his blood level contained a prohibited amount of THC, the active ingredient in marijuana. A trial judge acquitted him of operating a vehicle while under influence, finding he was not impaired at the time of the accident. But the judge did find him guilty of OVI for having too many marijuana metabolites in his system. Balmert argued his vehicular assault charge should be overturned because there was no proof that having the drugs in his system impaired his driving and caused him to hit the trooper.
Your challenge is really just to the sufficiency of the evidence, right? So it's a question of whether a reasonable trier of fact could find that from the evidence.
Ultimately, the challenge here is sufficiency of the evidence of proximate cause. But Mr. Balmert was acquitted of being actually impaired.
The prosecutor argued the conviction should be upheld because Balmert could have anticipated taking hemp to control his medical issues could also impact his driving. Justices questioned whether evidence was presented to show he was impaired.
Did he actually testify that the presence of cannabis that was in his system impaired his driving to cause the incident that harmed the state highway patrol officer?
You are correct that there's no specific testimony that he being under the influence was that direct link. But Your Honor, given the fact that you can more than infer based on the fact that you have diminished reaction time and the fact that he's saying he's under the influence from the cannabis, that was a causal factor.
A Franklin County man used a fake name on the marketplace app LetGo to set up a robbery. A deputy used a subpoena to get records of the robber and received GPS information showing the last time the man used LetGo, he was at a McDonald's. The deputy was able to get an email address and from that found the robber living close to the McDonald's. Mamadou Diaw argues the evidence cannot be used to charge him with crimes because the police needed a search warrant to get GPS info from his cell phone, even if it was just one location point.
You're arguing that how the data was collected is irrelevant. In other words, pinging cell phone towers to create the pattern of your movements over a series of years versus using a third party to obtain that information about an individual.
As we said very simply, if law enforcement wants to use a cellular user's data inside their phone, they need a warrant.
The prosecutor argues that cell phones provide location data when they are turned on, and that information requires a warrant to search. But GPS data provided by an app someone uses is not the same and does not require a warrant.
So you would agree with my earlier question that the big difference here is Letgo is by choice versus cell phone is just a cell phone.
Right, that's one of the big differences. That is certainly a key factor here. The driving point in Carpenter was that having a cell phone is indispensable. The decision to create a Letgo account and then to voluntarily log on to the Letgo account is an affirmative choice.
Chief Justice Sharon L. Kennedy announced the court will take the arguments under advisement and inform the parties of its decisions. The court meets for oral arguments at the Moyer Judicial Center in Columbus. Each session begins at 9 a.m. You can also see them live online at supremecourt.ohio.gov.